Well, welcome back, folks, to another episode of American Genesis, the creation of America's scripture, where we're looking at the documents that are the formation of the basis of our government. And we've been looking, last week, began looking at the judicial branch as outlined in the Constitution. So we're going to work on that again today. We probably won't finish it. I was hoping we might get done with it, but I talked a little bit too much last week, so we didn't do that. But let's hear a little bit of music first.
If tomorrow all the things were lost I'd worked for all my life, and I had to start again with just my children and my wife, I'd thank my lucky stars to be living here today, 'cause the flag still stands for freedom and they can't take that away. And I'm proud to be an American, where at least I know I'm free. And I won't forget the men who died and gave that right to me. And I'd gladly stand up next to you and defend her still today. 'Cause there ain't no doubt I love this land. God bless the USA.
Okay, well, I thought in honor of the fact today that today is Inauguration Day, we just inaugurated our new president, the 47th, Donald J. Trump again. I thought I'd ask a trivia question that had to do with inauguration speeches. Which president gave the longest inauguration speech in history? Okay, well, William Henry Harrison, March 4th, 1841, who at that time was 68 and was the oldest president ever inaugurated until Ronald Reagan. And of course, now both Joe Biden and Donald Trump have succeeded him in that. But he was the oldest president ever inaugurated. He gave a 2-hour speech of 8,445 words. To give you an example, President Washington's second inauguration speech was 700 and some words. Give you an idea of how long it was. It was a cold day. It was a wet day. Because of his elderly age, he wanted to portray himself as being vigorous and youthful, so he didn't wear an overcoat, gloves. And within 2 weeks, he had become deathly ill. Now, he was diagnosed with pneumonia. Some people think he actually died of typhoid fever because the spring that fed the water system to the White House at that time was right below where they dumped all the sewer from Washington, D.C. So he very well could have died of typhoid. But they diagnosed him with pneumonia. And they treated him with typical situations back in these days. They put suction cups on him to draw out the disease, blistered him with mustard packs. They bled him like they did George Washington. By the way, that's how George Washington died. They bled him to death. And they finally gave him a whole bunch of purgatives, thinking that would get rid of all the stuff. And he ended up becoming extremely dehydrated, vomited, diarrhea, etc. When that didn't help, I couldn't believe this. I just read this today. They decided they'd go to an old Indian remedy, and they got a whole bunch of live snakes and put all over him laying in bed. I've sat there and thought to myself, if I didn't die of the disease, I probably would have died of fright at that stage of the game. Just think about it. The guy has been bled. He's got blisters all over his body from these mustard packs. And then on top of that, he's deathly ill, and they put live snakes crawling all over his body. That's enough to kill anybody. End up dying on April 4th. So he was not only the president who gave the longest inauguration speech, he's also the shortest lived president. Led exactly 30 days. So terrible situation, to say the least. But anyway, he holds the record for the longest inauguration speech. So, what did we do last week? Well, we began looking at the American judicial system as outlined in Article 3 of the Constitution. And we reviewed the 5 bedrock principles of the American judicial system, which included equal justice under the law, due process of law, right to a lawyer, presumption of innocence, and a trial by jury. Then we looked at the difference between civil and criminal law. And then we reviewed the different layers of the federal court. The Constitution only creates the Supreme Court. The Congress has created the other courts, which includes district courts, courts of district courts of appeals, and specialized courts, like courts for veteran affairs and military courts and things like this. We then looked at how federal judges are appointed. They're appointed by the president with consent of the Senate, and they're appointed for life. We looked at how this has become extremely politicized in the last half century. Before that, it was not so political. Basically, the Senate just deferred to the president and let him have who he wanted. Now it's become an extremely political situation. And in regard to that, we looked at the historic demographics of the Supreme Court and how those demographics have begun to change quite radically in the last 50 years. Up until the 60s, all Supreme Court justices were men, white men. And then we finally got a black man on the court. And then in 1981, we got a woman on the court. And now today, the court has 3 women and 1 black person. So it's it's definitely changed from what it was up until about 50 years ago. So how is the Supreme Court organized? Well, the Constitution speaks very little about the Supreme Court. It just basically says there shall be a Supreme Court. The result is the Supreme Court has assumed the power to create most of its own rules and protocols. Whereas the Constitution outlines what a president can do and how he's supposed to do it and what kind of powers he has, and et cetera. It doesn't do any of that with the Supreme Court. So the Supreme Court has kind of made its own rules. It has interpreted the Constitution in a way in which it sees fit for itself. Kind of an ironic situation. The size is currently set at 1 Chief Justice and 8 Associate Justices. But that is not mandated by the Constitution, and that can be changed. Historically, there was as few as 5, and there's been as many as 10 judges. Now, there have been attempts to change the organization of the court in the last, century. Franklin Roosevelt notoriously tried to pack the court in 1937 with 6 new justices, and he met so much resistance from the Congress because they did, even his people that support him said, we can't do this. It's going to create such a huge turmoil that we can't do it. And of course, if you follow the news, you know that there was talk back last summer that Joe Biden was going to attempt to create a whole bunch of new Supreme Court justices because they felt like the court was going in the wrong direction. Of course, that was before he decided not to run and before his successor, Vice President Harris, was defeated. So that's not going to happen now. It probably wouldn't have happened anyway, because I don't think the Senate would have gone along with it. Even some of the Democrats said, you can't do this. This is not a good idea. So, there's been attempts to change it, but I think it's pretty well set today with 8 justices and 1 Chief Justice. It's going to take a really critical situation to change the makeup of the Supreme Court. Now, what is the jurisdiction of the Supreme Court? The Constitution does speak of this. And by the way, it is the only court in America that has both original and appellate jurisdiction. That means there are some cases that clearly have to come before the Supreme Court right off the bat. And most cases come through appeal. But there's no other courts that have both original and appellate jurisdiction. District courts have original jurisdiction, And then those decisions can be appealed to the district courts of appeals. And we're talking about federal court system here. It has original jurisdiction in cases, in all cases between two or more states. So let's say Missouri and Illinois get into a conflict and they decided to sue each other. Then it would go immediately to the Supreme Court. It also has original jurisdiction if there's any cases brought against ambassadors or any other public ministers from foreign countries. So for the most part, original jurisdiction, there's not a whole lot of cases that get before the Supreme Court on this. The number of cases, in fact, heard upon the original jurisdiction accounts for less than 1% of all the cases ever heard in the Supreme Court. It's very, very rare to have a case of original jurisdiction. By far and away, 99.9% of all cases that reach the Supreme Court do so through the appeals process. Here's the case between Missouri and Illinois. It was over who owned the Mississippi River, and it was brought sometime way back. Can't exactly remember when. It seemed like 1904, I believe, or 1906, where there was an argument about who had ownership of the Mississippi River because the river had changed course, and the result was that they were arguing about who owned what. And the Supreme Court had to end up taking the case and deciding. By the way, if I recall, they decided in favor of Illinois. I may be wrong on that, but I think they did. So the Supreme Court also decides which cases it hears because, again, the Constitution doesn't say it has to hear a case. So the Supreme Court, to reach the Supreme Court, they have to agree to take your case. Now, there's three ways you can get a case can reach the Supreme Court. There's some kind of a writ of certificate. This is extremely rare. And this involves a request from a lower court to review its rulings to certify the correctness of the court's decision. For instance, let's say a court gets a case and there is no precedent, there's no, really, they don't know how to handle it. And they don't know for sure if they handled it right. That lower court can actually, request that the Supreme Court review the case and make a decision to see if they correctly decided it. I can think of one instance where that happened back in the 1920s when there was a lawsuit over who owned the airwaves. Because think about it. Up until that time, that was never a question about who owned the airwaves. But when radio came in, there was some dispute about, whether or not a radio station in Missouri could send its signal over into Illinois, and whether or not that radio station could then be taxed by Illinois. And I don't know that it was between those two states. I'm just making that up there. But you can see what I'm saying. In other words, if there's a case before the Supreme Court that can reach for the Supreme Court where there's never been any idea about how that case should be decided, then they can hear that case if they choose to. There's also a writ of appeal, which accounts for about 10%. So let's say that somebody thinks the lower court has made a decision that is in error or mistaken law. President Trump has recently appealed several cases of his to the Supreme Court. One of them had to do with his immunity. And of course, we all know by now that the Supreme Court decided that presidents have broad immunity while they're president for their official acts. And so he appealed a decision of a lower court to the Supreme Court. So that makes up about 10% of the cases. By far and away, about 90% of the cases that reach the Supreme Court reach that on what's called a writ of certiorari. A writ of certiorari occurs when four justices, called a rule of four, ask that a case be sent up from a lower court for review to determine the correctness of the court's decision. So if somebody sends in an appeal to the Supreme Court and they say, we don't agree with the lower court's decision, we want you to take it and we want you to decide whether or not this is a correct decision. It's not a mistake in law. It's not a decision or an error. It's a lower court's decision that the plaintiff feels is wrong. If 4 Supreme Court justices agree, then it can be brought before the Supreme Court. So if 4 of the 9 say, yes, we want to hear this case, it interests us, then, for whatever reason, it can be heard. That's how 90% of all cases reach the United States Supreme Court. Now, once it gets there, it operates like no other court in America. Okay. It's not a typical court in the terms that you have a judge and a prosecutor and a defendant's lawyer and a jury and all this. There are 5 steps where the Supreme Court takes when it hears a case. First of all, it requires that lawyers on both sides submit legal briefs. And then they hear what's called oral arguments. And then they consider other people. It's something called amicus curiae. We'll talk about this in a second. And then once they've heard all this, they go back into conference and they decide. They argue it out and make a decision. And then they issue their opinion. So, again, the Supreme Court justices, they sit here and they listen to both sides, and then they make their decision. It's different. There's no jury, nothing like this. It's not like they hear testimony or anything like this. They listen to oral arguments. So, first thing that happens, they have to submit a legal brief, the lawyers on both sides. And these briefs can be extremely long or they can be small. But they have to include a summary of the facts of the issues. They have to include any applicable legal precedents and opinions. So they tell the lawyers, if you expect us to decide in your favor, you're going to have to tell us what has happened in the past to make us, why this case should be decided in your behalf. And of course, they have to present arguments. You have to say, this is why we do it. This all has to be done in writing. Once the briefs have been submitted, the Supreme Court, this is the first step. Then they have several different things they can do. Number one, they can decide the case on the merits of the briefs. If they read the briefs and the court decides without anything else, saying, hey, this is so clear cut, either it's obvious that there's been an error and we're going to, make a decision for the plaintiff, or it's obvious the plaintiff has no standing, and so we're just going to forget about it. And they just basically dismiss it, say, we thought there was something here, there isn't. We've decided the case on the merits. They can refuse to hear the case further. They can read the briefs and say, there's nothing here. We thought there might be, there's nothing here. Obviously, they can send it back down to a lower court for review. And they do this quite often, folks. In other words, they'll hear a case and they'll listen to oral arguments in the briefs, and then they decide, well, guess what? We're going to send this back to the lower court and let them try again to see if they can solve the problem. Because, number one, we don't want to do it because it's too political. That's the real reason. They don't tell you that, but that's it. Or they can let the previous decision stand, something in legal terms called a stare decisis. In other words, they can say, hey, we've reviewed it, we've looked at it, we've listened to you guys, and the decision that was already happened was a correct decision, so we're not going to go any further than this right here. So this is an example of a writ of certiorari that was presented to the United States Supreme Court. I don't know what happened to it. I don't even know what it's all about. I just pulled it up because I wanted something over there. Okay. So that's the first step. The second step, if they decide to hear the case after they've read the legal briefs, then they establish a date for oral arguments. And so, each side gets to present their side. Now, the attorneys that can plead before the United States Supreme Court have to be approved by the Supreme Court. Not every lawyer can go before the Supreme Court. You have to meet certain criteria. And frankly, folks, uh, in larger cities, obviously, there's probably several lawyers that can practice for the Supreme Court. But you get into the smaller courts, for instance, my old stomping grounds of the Ozarks, there were very few lawyers that could argue before the Supreme Court. There, I can think of three of them that could argue for the Supreme Court and did argue for the Supreme Court. But for the most part, just a general attorney is not going to have a chance. I mean, they're not going to, you have to have certain credentials. You have to have standing with the Supreme Court to be able to present an oral argument. If the United States government is a party to the case, then the Solicitor General, who is in a sense the government's lawyer, decides, it presents the oral arguments or some of his people that work under him. The time is extremely limited. Generally, it's 30 minutes to a side. Now, if it's a bigger case, they'll extend this. For instance, I can remember when it was when they had the Bush v. Gore oral arguments when they were trying to decide whether or not back in 2000 who was going to be the next president of the United States. They actually ended up giving both sides about an hour, and each side got to go before the Supreme Court and got to argue their case before the Supreme Court. Now, again, this is not like any other court because the judges can interrupt them at any time. And if you want to really hear these judges, folks, are really, really, really intelligent. We sometimes think that they're, government officials aren't very smart. If you really want to listen to something, you ought to download, for instance, Bush v. Gore in 2000. I can remember they released the tapes of this, and I listened to it, and I was extremely impressed with the way the judges, they would interrupt these lawyers right in the middle. I mean, they will interrupt them right in the middle of a sentence and ask them a question that's totally not got anything to do with what they're talking about. And you've got to be pretty good to be able to keep your focus. And I can remember thinking to myself, there was one lawyer that was clearly over his head. And I can't remember which one it was. I think it had to do with the Attorney General's office in Florida. And you could tell that he was just absolutely way in over his head. He had absolutely no business dealing with the Supreme Court because they were just eating him alive. So you have to be pretty good if you're going to argue before the Supreme Court. You've got to be able to think fast on your feet, and you've got to be able to know your arguments backwards and forwards. Okay. Then the third step is consideration of amicus curiae. Again, this is a Latin term because the Supreme Court can hear arguments from interested third parties. For instance, you've got a plaintiff and a defendant in most cases, but maybe somebody else has an interest in the case. And so interested third parties can present legal briefs and can ask to be heard in oral arguments. And this is called an amicus curiae, or a friend of the court. There is absolutely no limit to the number of briefs the court can entertain. They normally don't entertain very many. I think the record was 1989 in the decision of Webster versus Reproductive Services, which was an abortion case. And the court listened to 78 different oral arguments and amicus briefs before they made a decision. An extremely huge number because there were so many parties interested in making in the court's decision about abortion. And again, the more interest there is, the more chances are there are going to be a whole bunch of interested third parties. Okay, so they've read the briefs, they've listened to the arguments, they can listen to third parties. They then go back and conference. And this usually happens within a few days of the oral arguments. Now, we don't know what happens there because this is all done in secret. There's no record. There's no written notes. They're supposedly not able to keep written notes. We only have a little bit of sometimes some of the Supreme Court justices have kind of let out a little bit of what's happened. But for the most part, folks, we don't know what happens in the Supreme Court. By the way, Supreme Court hearings are not televised. They absolutely refuse to let television cameras in. They do issue transcripts of the oral arguments, and on occasion, they will release audio tapes if it's a case of supreme importance. They did in Bush v. Gore. Usually, it takes months to make a decision. It can take only a few days. We just saw just the other day, last weekend, the Supreme Court issued a decision about TikTok. I'm not on any social media, so I'm not up with all this kind of stuff. But there was a Supreme Court case that reached Supreme Court about TikTok. They heard oral arguments last week and issued a decision this weekend. Within about 6 days, I believe it was, that they issued a decision. But they don't normally do this. It usually takes months to issue the decision. The conference is held in strict secrecy, like I said, with no one else in attendance. There's no legal aids. There's no notes taken. We know very little about it. We know that the Chief Justice speaks first, and then he is followed in order of tenure with the court. We also know that the conferences have at times been extremely spirited from what we've been able to hear, but usually they get along pretty good. By the way, there's a couple of interesting stories that have leaked about the conference of the Supreme Court. Two of them had to do with Sandra Day O'Connor. She was the first woman appointed to the Supreme Court. And the story got out somehow. I imagine she leaked it. That one of the traditions in conference was that the junior justice, that is the most recently appointed justice, was to go get refreshments because they didn't allow anybody else in the room. So she had to go out to wherever they were doing this and had to bring in the coffee and the refreshments and all. And I guess the Supreme Court justice, the Chief Justice said, Justice O'Connor, would you please go get us some refreshments? And she didn't realize this. And she said, are you saying you expect a little lady to get up and feed you guys? And of course, they realized then, we got something on our hands here we've never dealt with. And I believe they've changed the rules since then, where it doesn't have to be the junior justice. There was also a case involving Justice O'Connor, where there was only one bathroom adjacent to the conference room. And she said, if you think I'm using the bathroom you 8 guys are using, you're crazy. I'm not doing that. And they actually had to build another bathroom off the conference room so she could have her own bathroom, which makes sense. Okay. So all sorts of interesting stories that have come out of the Supreme Court conferences, but we really don't know anything. So they have a conference. Then they make a decision. Now, normally after the decision is made, one justice is assigned to write the opinion. And it's almost always a justice and obviously in the majority. Although any of the 9 can write an opinion. Usually they don't. Usually it's just one justice will be assigned. Okay, does anybody here want to write this opinion? And one of them will raise their hand and said, I'll do it. Maybe he's got a real interest in it or something. The decisions do not have to be signed. They can be issued per curiam. That is, you can have the decision made and decision will come out and say, it's the opinion of the court, blah, 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 blah. But you don't know who voted for what. So the vote can actually, it can be an unsigned opinion without knowledge. Most of the time, it isn't that way. There are 3 different types of opinions that can be issued. There's the majority opinion. So of the 9 justices, let's say 5 or 6 of them decide one way, and they say, this is how we're going to decide. And the opinion is issued with one of the justices or maybe more expressing the opinion. There can be a concurring opinion. In other words, maybe one of the justices agrees with the majority, but for a different reason. he'll say the majority of the courts said this, and this is why they said it. I don't necessarily agree with their reasoning, but I do agree with the decision, and here's why I agree with it. So they have a completely different reason for deciding that way. And that happens quite often. And of course, there can be the dissenting opinion. In other words, if you're on the losing side, you can issue a dissenting opinion where you outline why it is that you think that the decision reached by the Supreme Court was wrong. And sometimes those dissenting opinions do become majority opinions at some later date. Okay. So, again, here's an example. This was the Dobbs case, which is the most recent case that had to do with abortion. And you can see here, dissenting, Justice Breyer, Sotomayor, and Kagan dissented. And the rest of them, basically agreed with the Supreme Court, with the majority of the Supreme Court. Now, all this takes place because of the process of something called judicial review. Now, you can read the Supreme Court, the Constitution, till you go blind. And nowhere in the Constitution does it say anything about judicial review. It is the single most powerful tool that the Supreme Court has at its disposal. Now, it's an old concept in law, and the British had it, and that's where we end up getting it from. But it's not stated that the Supreme Court has that power in the Constitution. It has assumed that power. That power is the ability to decide on the constitutionality of an act of government. So the Constitution doesn't tell us the Supreme Court has the power to decide that acts of government, either executive or legislative, are unconstitutional. They just assumed that power. They have assumed the power as the ultimate arbiter on disputes between states and the U.S. And like I said, that's not exactly specifically stated. Now, there's some scholars that say the power of judicial review is unconstitutional in itself. That's really stretching it quite a ways, folks, because like I said, the British, before we became a country, in their common law, had the power of judicial review. And Madison and Hamilton and Jay all spoke of judicial review in the Federalist Papers. So even though it's not mentioned in the Supreme Court, we know that the founders of the United States Constitution assumed that the Supreme Court would have judicial review. They just didn't put it down in the Constitution. So the bottom line is this: since they've assumed the power, there's no way that anybody can take it away except by constitutional amendment. You're going to have to pass a constitutional amendment saying the Supreme Court does not have the power of judicial review. That's never going to happen. Okay? Trust me, it'll never happen. The case where this was decided was the case of Marbury versus Madison in 1803. This, by some accounts, is the single most important case in Supreme Court history. Kind of between it and another case, but I personally think this may be the single most important case in Supreme Court history because it is where they clearly established the power of judicial review. This case is worth reviewing. So I'm going to take about the next few minutes and we're going to review the Marbury versus Madison case. Here's what happened. We had an election in 1800. And the Federalist candidate, John Adams, was soundly defeated by Thomas Jefferson. Adams and Jefferson were big enemies at this time. They eventually made up, and if you know your American history, and I've alluded to it, they actually died on the 50th anniversary of the Declaration of Independence, July the 4th, 1826. But at this time, after the election of 1800, they absolutely were furious with each other. Adams was extremely upset that he had been defeated, and he blamed Jefferson and his cohorts for making it such a horrible election in his mind. Since there was 5 months at that time between the election and the inauguration, the election was in the first week in November, and the inauguration was then March the 5th, I believe, or the first Monday in March. So there was about 4 to 5 months time period between the election and the inauguration. The Federalists, in a lame duck session of Congress, decided they were going to pass a law called the Judiciary Act, where they created several new federal judgeships prior to Jefferson taking office. They thought, well, we've lost Congress, we've lost the presidency, much in the same way that's happened right now. And so they passed a law creating a whole bunch of new judges, thinking we will create all these judgeships and we'll fill them, and at least we'll have one branch of government on our side. So by the end of the term, Adams had appointed a whole bunch of new judges, attempting to pack the court with federal judges. However, some of them were in the last minute, and the result was that after Thomas Jefferson was inaugurated, they found some of these commissions that had not been delivered. And so Jefferson told his Secretary of State at that time, James Madison, he said, don't deliver these. We're not going to fill these commissions, even though, the Congress passed a law, and even though Adams appointed them, the commissions had not been delivered to these new judges appointing them. So he said, don't deliver them. And so James Madison withheld delivering these commissions that had not been delivered. One of the people that sued him that had not got their commission delivered was a man by the name of William Marbury. And he ended up suing James Madison, the Secretary of State, because he said, I was appointed a federal judge by the president. I was approved by the Senate. And even though my official commission was not delivered, I ought to have that judgeship. And so they appealed it, and it reached all the way to the Supreme Court by 1803. Now, by that time, the Chief Justice of the Supreme Court was John Marshall, who ended up being the Supreme Court Justice for like 30 some years. And a lot of people consider him the greatest Chief Justice of all time, because he is the person that was responsible for actually structuring the Supreme Court as we know it today. He was also a Federalist, an advocate for John Adams. So here's the problem. He knew that if he issued what was called a writ of mandamus, where he ordered Madison to deliver the commission, that Jefferson would in turn order Madison to ignore it, and the Supreme Court couldn't do anything about it. So the Supreme Court could say, you were mistaken here. You have to deliver these writs of commission. And if you don't deliver them, we're issuing a writ of mandamus telling you have to do it. But Jefferson could ignore it because the Supreme Court doesn't have any power to enforce. That's the executive branch. However, he also knew that if he denied the writ of mandamus, it would look like he had catered to Jefferson. And he didn't want to do that because he was a Federalist. He was a supporter of Adams and the Federalist Party. So he had to come up with a decision, and the Federalists controlled the Supreme Court. So whatever Marshall decided they were going to do, they had to come up with a decision that would basically satisfy both sides. And the result was that his decision was extremely important, to the point that it, like I said, most scholars agree it's the most important decision in history of the Supreme Court. It also shows how the Supreme Court is involved in the political process. Now, every Supreme Court justice will tell you we are non-political. We approach this in a completely non-political way when we make a decision. Folks, that's baloney. And it always has been, and it always will be. It's more obvious today than it was 50 years ago, because we have TV and 24-hour TV and court experts and all this, and they tell us what we need to know. It's always been political, but it's just more obvious today than what it has been. So what did he decide? Pardon me here. I'm still fighting my Michigan cold to a degree. Okay. Okay. Got about 5 minutes. The court made two major rulings. Number one, it said under the Judiciary Act of 1789, Madison should have delivered the commission to Marbury. So they said in a sense, President Jefferson, you were wrong. You should have ordered your Secretary of State to deliver this commission. You made an error according to the Constitution. But then it held that the section of the writ of the act that gave Congress the power, or pardon me, the writ of mandamus to the Supreme Court exceeded the authority given to the court. So it said, yes, you should have delivered it. But since that part of the law where we had to decide that we could issue a writ of mandamus was unconstitutional, then it's a moot point. So they chastised Jefferson and Madison, but at the same time created a situation where the court order would be ignored, thus making the court look weak. And everybody said, or at least all the Jeffersonian people said, oh, it's great. We won. And then they woke up the next morning and they got to thinking about it and said, wait a minute, what did the Supreme Court just do? First of all, they declared an act of Congress unconstitutional. They said the writ of mandamus was an unconstitutional act. You didn't have the power to create that law. Nobody had ever said that before. This was the first time the Supreme Court had said we have the power to declare an act of Congress unconstitutional. They also said, by the way, President Jefferson, you should have had that commission delivered. So your action was unconstitutional. When all of a sudden Jefferson and all the other people realized, they thought, what has the Supreme Court just done? They have basically become the final authority on what the Constitution means, judicial review. It was a genius stroke on the part of Marbury, and it established the primary power of the Supreme Court, which has never been disputed from that point forward. Now, wisely, the Supreme Court did not use this power very often in the beginning. In fact, case it was not until 1857 that they used the power of judicial review again. And even then, it was used extremely narrowly up until the 1960s. And then starting in the 1960s, the court began to really use, become politically involved and use the power of judicial review. So that's what we're going to stop today. What we're going to do next week is we're going to look at the pardon me here. We're going to look at the, politicalization of the Supreme Court. What has changed from the 1930s up through the 1960s, the 70s, 80s, 90s, up until the present time? How has the court changed in how it looks at decisions? Okay, so I hope I'm not bored you too bad today. I hope you've enjoyed it. I hope you've learned something. Trust me, the Supreme Court is a really unique animal, and it has always intrigued me on how it operates. So next week we're going to finish up the judicial process, what's said in the Constitution, by looking at the politics of the Supreme Court and how it has changed over the period of about the last 60 to 70 years. So I thank you for being with me today. I hope you learned something, and we will see you next week.